Welcome to This Explainer. Today, we're diving into the fascinating intersection of law and medicine in India, uncovering the rules, the systems, and the future of organ transplantation. I'm thrilled you're here because this is a framework designed to literally save lives. We're going to break down the legal guardrails that govern one of the most complex, emotional, and vital medical processes out there. Here is our roadmap for today. We'll cover the legal framework, look at living versus deceased donors, check out how NATO coordinates everything, tackle the massive challenge of consent, and finally, look at some proposed future reforms. Let's get right into it. So why does all this legal stuff matter? Well, we have to start with a truly staggering crisis. Every single year, 500,000 Indians die waiting for an organ. 500,000! It's a heartbreaking reality, representing mothers, fathers, children, and friends who simply run out of time. Now contrast that massive demand with the actual supply. Right now, fewer than 15,000 transplants are actually performed annually. Think about that gap for a second. The chasm between 500,000 and 15,000 is exactly what the Indian legal system is desperately trying to close. All right, part one. Let's look at the legal framework itself, specifically a law known as THOTA. If we look back, India actually transitioned from this really dark era of unregulated, exploitative kidney bazaars to officially passing THOTA, the Transplantation of Human Organs and Tissues Act, in 1994. This was a massive landmark moment. It made India one of the first developing nations to firmly crack down on commercialization. And then in 2011, they came back and added crucial amendments to expand the donor pool and bring tissues into the legal fold. You know, one of the absolute game changers in this law was legally defining brain death. Before THOTA, the lack of a legal definition created a lot of confusion. Today, brain death is recognized as a permanent, irreversible state equivalent to death, and it has to be certified by a strict panel of 4 doctors. This gave hospitals and grieving families the medical and legal certainty they actually needed to move forward with organ retrieval. Moving on to part 2, let's break down exactly who can donate, looking at living versus deceased donors. The law sets up a really clear distinction here. For a living donor, you have to be an adult, near relative, driven purely by altruism, and you need approval from a special committee. The 2011 updates actually expanded the definition of near relative to include grandparents and grandkids, which is fantastic. Deceased donation, on the other hand, hinges entirely on that rigorous 4-doctor brain death certification we just talked about, plus strict family consent. Oh, and those progressive 2011 amendments introduced something brilliant called swap donation. Imagine 2 families, right? Both are willing to donate to their loved ones, but medically they just aren't compatible. The law now lets these pairs ethically swap donors with each other. It treats this as altruistic because the primary motivation remains saving lives, completely expanding the donor pool without any illegal commercial exchange. But wait, how do we make absolutely sure money isn't quietly changing hands? Enter the authorization committees. These state-level bodies act as the ultimate gatekeepers against exploitation. They literally sit down and interview the donors and recipients completely separately. Their whole job is to verify that the donation is entirely voluntary and that there is absolutely zero commercial motive involved. Okay, part 3. Once organs are legally procured, how are they distributed? That's where NATO comes in. The Act actually established this highly structured 3-tier coordination network. It starts up at the national level with NATO, flows down to regional ROTOs, and then to state-level SOTOs. When a deceased donor's organs become available, this grid kicks into high gear. We're talking real-time tracking, allocation, and lightning-fast transport, sometimes even getting commercial airlines and traffic police involved to coordinate a national emergency delivery. And here is the really crucial part that illustrates the equity built into the law. The allocation is based strictly on transparent medical criteria. You literally cannot buy your way up this waiting list. It all comes down to blood group compatibility, how long you've been waiting, the absolute urgency of your medical condition, and geographic proximity. Now, amidst all this rigid legal and medical infrastructure, we absolutely have to highlight the transplant coordinators. These folks are the human bridge. They are deeply empathetic professionals who step in during a family's darkest, most painful moments to navigate these dense legalities. Because identifying a potential donor is only half the battle. Respectfully guiding a grieving family through the consent process is what actually saves lives. Which brings us right into part 4, the massive challenge of consent.
If we zoom out and look globally, there's a huge contrast in how countries handle this. India uses an opt-in model, meaning the burden is entirely on grieving families to give explicit consent at the time of death. But countries like Spain and Singapore, they use highly effective opt-out models. That means presumed consent. You are automatically considered a donor unless you explicitly opt out. India relies entirely on families making an active choice at the worst possible time.
And here is the major friction point with India's current law. Even if you go online right now and pledge to be a donor, under THOTA, that pledge is not legally binding. The ultimate legal authority rests solely with your next of kin. So if your family says no at the hospital, the donation simply does not happen. Combine that dynamic with severe grief, a lack of public awareness, and systemic distrust, and it becomes a massive, massive barrier. So, where do we go from here? Part 5. Proposed future reforms to close the gap.
Experts are strongly arguing that this legal framework absolutely has to evolve. A lot of people are calling for a pivot toward that presumed consent or opt-out model. Another huge proposal is mandatory hospital referral laws, meaning hospitals would be legally mandated to report every single brain-dead patient to THOTA. If you legally expand the reporting pool and pair that with a digital registry tied to national IDs, you suddenly have a realistic roadmap for systemic change.
And real quick, before we wrap up, it's so important to remember that this framework also protects tissue donation. Those 2011 amendments brought life-saving tissues like corneas, skin, and bone right into the fold. The beautiful thing here is you don't need to be in an ICU on a ventilator to donate tissue. Almost anyone, regardless of how they pass, can leave behind the incredible gift of sight or help heal severe burns. Ultimately, because the law places the final, decisive power in the hands of your next of kin, we want to leave you with this critical question to think about tonight. Does your family actually know your choice? Because honestly, the strongest legal framework in the world cannot bypass the need for a simple, honest conversation with the people you love. Talk to your family. It just might be the conversation that saves 8 lives. Thanks so much for joining us on this explainer, and we'll see you next time.